wanted to ask, do you have statute of limitations on certain matters here as well in the UAE? Do you know what I mean by statute of limitations? Okay. Do you have those? You do. Okay. In the United States, the limitation as to the time that you can bring a case may vary depending on the type of case it is. Is that how it is here as well, depending on what type of legal matter it is?
In each case, we have a time bar. But what I mean is, once the case is closed, we have a judgment, first degree, appeal, cassation court, and the file is closed completely. There is no more court case. And that file is no more used. I have claim for money, I collected the money from the client. So for me, it's only a storage for me. And a lot of time, we keep the client. We send a letter, we send email to the client. They refuse to receive it. We say, keep it with you.
Mm-hmm. Yeah.
So what shall I do with that? We have stores, we hire stores, we have, okay. At the end of the day, we find it that after 5 years, okay, when nobody is coming to claim the document. Of course, we don't destroy the original document.
Right.
Everything which has been legalized, has been stamped, or document coming from abroad, we don't destroy it. We keep it aside. But we will scan the other document, we destroy the other. So if the client wants to retrieve his file, I'm able to retrieve his file immediately, but not the physical file that it was signed.
Right. Okay.
Mm-hmm. And that's similar to what we do in the States as well. And I just want to relate another story to you. And this was at one of the seminars that I was speaking. One of the paralegals came to me afterwards, and she was working at a large firm. So this is larger firms. They have policies and procedures, manuals, and staff retreats where they go over how things should be implemented, the rules, which means then that it is important for management to not only continue to have this discussion with the staff, but have them appreciate the importance of it, the why. We would think that this lawyer who is bound by ethical obligations to the client and has taken the bar and passed the bar and understands the ethics rules, that he would appreciate the importance of not just giving that simple instruction to the secretary. But nonetheless, for whatever reason, maybe he was having a bad day or just didn't care, I don't know. But the importance is that as you as the owner and we as the owners of our business, of our practice, it's our reputation at stake, that we need to continue to explain why. Why is it that we do something? This is not a futile exercise. It's not something that we're just doing to punish someone, but there are reasons why we're doing it, for the reputation of the firm, the reputation of us as owners, and the reputation of, in that case, the other attorney, because that attorney would have problems if that client ever sued. And it could have been a matter where, similar to what you're saying, it's over with, it's done, maybe the client might have been deceased or whatever, but to treat the treat the document so casually was not appropriate. So, speaking about the review of the files, and as you as a manager, there should be a periodic review. If it's electronic, we as lawyers, or if not the lawyer, but someone that you can trust and who has a good sense of judgment, should audit the work process to make sure things are done. So, for example, let's suppose that I have put something up on the web. It's a document that needs to be put up, and I'm having several of the legal assistants working on this document and working with maybe a junior lawyer in finalizing this document. And so it's there on the web. I need at some point to check in, or have someone check in, to make sure there is movement, there's some activity on that document, and that we're moving along. Otherwise, information or responsibilities are handed off, and we have no idea whether they are being completed or not. There needs to be follow-through. Someone needs to follow up on the follow-through. So auditing the work process as it relates to electronic files can be somewhat difficult because there is no paper trail. That means that someone needs to go in and look at the electronic to see if someone has been updating, keeping, let's say, for example, the proper record keeping on electronically, updating the documents as fit, detailing or putting notations in the electronic file as to what has been done and what each person has been done and what's the next step for someone else. Because without a paper trail, it's somewhat difficult to know who's done what, who made this change, who authorized this or that. So requiring that there are notations to the electronic file as to what each person has done and what is left to be done is helpful. With the paper file, we would have to check to make sure, one, that all the papers are included. Because as I mentioned before, sometimes an attorney looks at the file and has to remove something to make sure it gets back in there. If there are loose papers in the file, let's suppose your office procedure is to include having it bound in the folder and have the 2-hole punch and everything should be 2-hole punch. And you look at the file and you see that there's a paper just stuck into the folder. Why is it stuck in the folder? Is it something that an attorney has put or someone else has put in the file and it has not been properly checked in or looked at? If it's an important document, have you seen it? Is that the reason why it's out? So asking the why is not just a matter of the what and saying, oh, this paper is out, make sure it's put in, but why is it out? Making sure that it has gone through whatever procedure that was needed for handling urgent matters. As we talked just briefly about the statute of limitations, and I'm sure with the statute of limitations here or other deadlines, it's important that we meet those deadlines. If this is a document that maybe has come in the mail and it did not come through, it did not get the benefit of being seen by you, then you would not know that this is something you need to attend to. So seeing that loose document should alert you to check and see, well, why is it loose? Has it gone through the procedures that I've set up in my office? Is this something that is urgent that I need to handle? And if it is, then that means we need to take our employees aside because there is, when people are not following the procedures, then it's not helpful to our practice. And we need to sit down with that person and let them know to follow. In the States, it's important that we communicate frequently with, or not so much frequently, but we periodically let our clients know what is going on with their matter. And when we are looking at whether it's an electronic file or paper file, as part of our review, we want to ask the question as to when was the last time we communicated with this client. And I'm talking about open files. These are not closed files. So as long as this file is open, when was the last time there's been a communication sent to the client? If there has not been some written contact with the client in the past 60 days, then we need to do that. As was mentioned before, sometimes in our billing, if all our client gets is a bill, but we haven't communicated at all with the client by letting them know what we have been doing or sending copies of our work, whether it's a filing or pleading from the other side, sending copies of that to the client, then as far as the client is concerned, we haven't done anything. And if we haven't done anything, why are we sending a bill? And that is how we get sued. So in the periodic review of the file, we are looking to see who was the last one to contact the client and how much contact have we had. And to the extent it is overdue, we make a point to contact the client and let them know that we still care about them. They like to be touched. They like to feel that we think about them. Also, look for misfiled documents. As I mentioned before, especially with the paper files, it could be something that's either misfiled or lost, or temporarily lost, and we need to take time to find it. If it is an electronic file, sometimes the name is wrong, and you look at the name and say, gosh, 5 years from now, we'll never retrieve this file, because no one would think to retrieve it by that name, and you take the time to come up with a better name. Okay. Next, I just want to briefly talk about bank accounts. I understand that not everything is going to apply here, but I do want to at least talk about how we have bank accounts in the states as it relates to the practice. Well, one, we have an office account. The office account is the bank account where you would, all the fees that you earn, the income that you earn, is deposited into the bank account, the office account. Any expenses of the office, paying salaries to the employees, rent for the building, utilities, other overhead expenses, that would go into the office account, expended from the office account. If you do any travel related to a client matter, any business-related travel, that would be coming from the office account. So all your office expenses and the income that you earn would go into the office account. What we also have in the States are client accounts, money that is not ours, but money that is of the client. Similar to as how you have it here, and we encourage our attorneys to get money up front, because when the client gives money up front, they're more apt to pay your bill because they've given you some money. They're more invested in the case. But that money, when we get it before we've done any work, is not ours. It is still the client's money. And our ethical rules require that we segregate that money from our own. We cannot commingle funds of the client with our own. Therefore, we must set up a separate bank account for the client with that money in it. And we call that a trust account, the client trust account. So that is in a separate bank account. It could be at the bank where we have our office account, or it could be at a different bank. But it is a separate account. If the money is large, we would have a separate bank account for each client that has large amount. If it's a very small amount, then our local bars our jurisdictions would allow us to keep those small amounts in one trust account for at a bank. So if client A only gives us $25, but if that, or 25 dirham, which is a very, very small amount, we still cannot put that money in our office account. But it costs too much money in terms of bank fees to put 25 dirham in a bank. But if we have other client monies that we put it in with that in that bank account, and it will still be under the client trust account. It's just not under that particular client's name. But our clients that we would charge a lot of money for, and we have a lot of money, we would have a separate account for them under their name. And the purpose again is to not segregate, is not to commingle our money with the client money. And as we earn the money, we are able to take it out of the client trust account and put it into our office account. And that's how that works. Or we are required to take it out. Because once we earn that money, it becomes our money and it cannot stay in a trust account. The other type of bank account that we have is a personal account. So for me personally, for my own personal expenses. And for many solos in the States, since they do not have to legally create an entity for their law firm, they and their law firm are one. and they would operate that law firm out of their personal checkbook. So they pay their housing expenses, and they also pay the business expenses of the practice. I strongly discourage that and ask them to, even if they and their practice are one from a legal perspective, that they have a separate office account for the practice and have their personal account segregated or separate as well. And that is to make sure from a managing perspective, when they look at the performance of the firm, that it's very clear what that expense is. Is it a housing expense for the lawyer personally, or is it a rental expense for the law practice? So having those separate accounts. So the office account, client trust account, and the personal account.
In the UAE, expatriate, we have a labor employment. At the end of when they leave their jobs, you have to pay them end of service benefit. End of service benefit is counted on their basic salary all along their life. So I believe that even lawyers has to have a separate account where they put the end of services of the employee. That like this, they will not be surprised if they have one employee after 10 years he wanted to leave and he doesn't have the money. So we can put this money at trust. Mm-hmm. It is also advisable, I believe, that the solo lawyer will fix his salary for himself mm-hmm. and get this salary cashed by himself at the end of the month like any other lawyer. Mm-hmm. So he may manage his money in a better way also. Thank you.
So the second point first, having a separate office account allows the solo to better manage the money because it's separate and distinct from the personal account. But going to the first point that you mentioned about having this money available for employees who end up leaving, so this is money that is being accrued over time. And so you have to keep track of it. And may I ask, do you send out interim statements to the employee to let them know what it is over time?
We don't send them statement of account, but the employees in the office, they know that there is an account at the bank under the name a trust for the end of service benefit. So if the whole employee of the office are leaving today, mm-hmm. all of them, okay,
you have to pay.
I don't have problem by searching money from anywhere because that money is already set aside. And the employee knowing that, they are more relaxed, I believe, and I am more relaxed that this employee at the end of the day, when they want to leave, they take their account. I don't need to fetch for it.
Okay, and if I may ask, is that part of the local regulations that require you? That is
no. It's a personal policy that we find it's easier to be put it in such a way. So at least it gives you, as employer, you give you peace of mind. Mm-hmm. And for the employee, it gives them a guarantee that if the economical situation is not good for the office, mm-hmm. at least I still have my end of service benefit aside.
Right. So for clarification, on both the end of term benefit, that is something that you choose to do and not something that is required?
No.
So that is required.
It is not.
The end of
payment to end of service benefit is required by law.
Okay, that part is required, but how you keep track of it, that's up to you as to whether you...
Exactly.
Okay, good.
Exactly.
Okay, that's very good to know. And so it does make sense to have that, a separate account for that, because when that money is, even if you are keeping it aside, if it is part of your office, it's hard to know when you are dipping into the amount for the employees versus the amount that you set aside for your office. So having a separate account is preferred. Mm-hmm. Thank you for that.
Excuse me, please. May I comment? Because in some jurisdiction out of the UAE, it is compulsory for the employer
yes.
To put the money in what is called social national insurance fund. Mm-hmm. And it covers the responsibility of the employee with regard to the after-service benefit at the end of the services. But in the UAE, for example, this suggestion seems very good, but I have a concern here because sometimes, according to the UAE labor law, employees, even he spend a very long time, he may be precluded from the after-services benefits. If from day one, he knows that there is a money put in a separate account under his name as a trust just to cover the after-service benefit, he may come to a conclusion that this money become his money. Maybe they may treat it as acquired right. And unfortunately, there is some practices up to the high-level court that if you give the employees any indication that this money or this rights become one of your right, you may not be able to take it out from him. Yeah, this may be just one of concern. Yeah.
Don't tell the employee that you are getting on top of your salary a certain amount. No, you make a calculation, accountancy calculation for your own firm. You have one employee who got 10,000 dirham and he worked with you monthly and he worked for you 10 years and he quit today. How you calculate his end of service benefit? You have to look on the law and to follow that. What I'm saying that he will get how much money he will be having, he will know it at the end when he leaves this job. But the money due to him is already in the separate bank account. It is within my account, it's the account of the office, but I segregate it, I put it aside in order me not to have problem for the future. Thank you.
I understand that because for you, you need to actually to manage the situation to avoid any risk it may occurs to you at the end of the services. But my concern is still there because in some jurisdiction like UAE, I have been almost working here for years. I'm dealing with a lot of labor cases, although I'm expatriate, but the practice from the expatriates is very bad, by the way. They try to revolve around any facts in order to get more money, in order to get more benefit. Such practices, it is genuinely, it is a very good idea, no doubt of that. This is why I said before, in some jurisdiction out of the UAE, it is compulsory for the employer to put a certain percentage from the salary on monthly basis in certain fund under the government control, and it covers the employer's responsibility at the end of the day. But here, the situation may be a little bit different because in some cases, if the employee has been terminated for any criminal matter, for example, he will not be entitled to any after-service benefits.
Very interesting. So it seems that there might be some variations based upon local, but we have something similar, I guess, with our pensions. Something similar in terms of employers providing certain pension benefits or retirement benefits, but it's not so much just for end of service as it is for our retirement. But once it has accrued to our account, then we keep it. But it is something that we do get notification of for every pay period, that we see how it is accruing and moving. So it's a little different. No, you want to?
أنا مختلفة معهم في الكلام اللي يقولونه. القانون واضح. القانون كان واضح. القانون العمل كان واضح.
We can't hear the. Yeah, channel 1.
I got it.
أوكي. قانون العمل كان واضح. وضح وحدد بالضبط بالنسبة لنهاية الخدمة.
We're not getting.
Okay, you can hear now.
Oh, number 2.
Okay.
Okay,
Okay, channel 2.
Okay.
It's 2.
I don't know, we're on channel 2 now, but we hear you. Go ahead.
Okay.
Okay.
قانون العمل كان واضح. وضح بالنسبة للعمال كيف نهاية الخدمة. أنا مش فاهم شو طبيعة الخلاف بين الأساتذة. القانون واضح. في حالة إذا العامل لم يستطع أن يحصل على نهاية الخدمة، بإمكانه يرفع قضية، لكن هو حقوقه مضمونة. بإمكانه أنه هو يروح المحكمة، بإمكانه أنه يطالب بمستحقاته، سواء كانت الرواتب، سواء كانت مستحقاته على نهاية الخدمة، والقانون هو اللي يحدد أو القضاء عفوا، القضاء هو اللي يحدد من الغلطان، سواء صاحب العمل سواء العامل، وكل ذلك عن طريق المستندات. مستندات العامل يوفرها، مستندات صاحب العمل يوفرها، والنتيجة تكون أمام المحكمة، محكمة مستندات. فأنا مش فاهمة شو الخلاف بين الأساتذة. القانون واضح والقضاء موجود. Thank you.
Okay.
I don't say that you are. What has been suggested by this gentleman that he's. I think I said it's very generous. It is very good idea, no doubt of that. But my concern, it may create a problem for the lawyer in the future if, in case that the employee has been terminated for any reason that he is not entitled to after service benefit. This is just my concern.
But I would think though that it may be it's still a good practice to segregate, to accrue and accumulate the funds and to segregate them. One, to accumulate the funds so that one has the money when the person leaves, have that available. To segregate it because you can account for it easily. But if there is an issue that by the law that person who leaves is not entitled to it, that's a separate question. I don't think that by the lawyer accumulating and segregating necessarily, and I can't speak for the law, would necessarily entitle that person as a matter of right to those funds. And it may be, as was mentioned, it may be something that's up to the court to make that final determination as to whether the individual should receive it. But nonetheless, the lawyer is ready and able to provide the funds if the court says the person is indeed allowed to or eligible to receive those funds. Mm-hmm.
اوكي، عندي سؤال. ذكرتي ان في برامج كمبيوتر بامكاننا ان احنا نستغلها او نستخدمها في المكاتب، شو اسامي هالبرامج وكيف ممكن ان احصل عليها؟ هذا اول سؤال.
I had mentioned Abacus Law and PC Law. Those are two of the major software for timekeeping and accounting, and they're more user-friendly. So those are two. If there's also on the web, if you put in software for lawyers, if you Google it, a lot of competition would come up. The Google, even the Arabic version. Yeah, the Arabic version. But I would think it would still come up, though, in terms of the different software. But just as in the States, even though there might be software out there, you really need to be able to see that and to have that software demonstrated so you can see how useful the various functions are and how user-friendly that software is, whether it's you utilizing the software or someone else. But the timekeeping and the accounting integration is going to be important. In the States, there are some lawyers who, I don't know if you've heard of this software, it's called QuickBooks. And QuickBooks is for any small business. But some lawyers who are small enough, they use it because it's very user-friendly. It was created for the person off the street who decides to start their own business, who, of course, as a result, would have varying degrees of experience working with software or having an understanding of accounting. So it's very simple to use. However, with that simplicity, there is a price, and it cannot necessarily track from an hourly basis. It's no mechanism in place from a time management to help you manage your time, to record the management of your time. It is strictly an accounting software, but there are many lawyers who do utilize it.
I'm curious if you all are using software, are you finding it difficult to find Arabic versions of software to use? I mean, I have no idea if these major softwares are in Arabic. That's a problem. Yeah. Turn on your microphone, please.
في بعض المكاتب تستخدم بعض البرامج لكن مش موجودة بالنسخة باللغة العربية. يعني يا ريت لو تتوفر النسخة الأمريكية. ممكن تكون مثلا موجود منها النسخ اللي يستخدمونها في الدول العربية. لكن هي غير يعني مو على كفاءة معينة. احنا محتاجين، او انا بالنسبة لي محتاج ان انا اطلع على النموذج الامريكي حتى اني انا استفيد منه، لان اكيد انه هو متطور.
And that may be a discussion we may need to have as at the American Bar Association, talking to some of the vendors of software for them to look at developing an Arabic model. I know Lexus, with PC law, they might be more interested in it. There has to be a larger firm that is able to have the resources to do that. And if it makes financial sense for them, I'm sure they would. But I think some conversation by the ABA with them would be helpful to get them to move in that direction. So thank you for that comment. As it relates to billing and collecting fees, as was mentioned, there are different variations in the fee structure. And in order to bill a client, as I spoke briefly on, it's important that we capture initially the time and spent on the client matter, and also the description of the service that was provided, down to the phone call, the letter that was written, the negotiation with another attorney, a discussion with another professional. All that needs to be written down, so in the event if you had to go to court to defend your fee, it's already there. And most importantly, just conveying that information to the client, communication to the client. In the states, as part of the ethical rules, we have the obligation to communicate to the client. That is actually in our rules. And effective communication of the client, oftentimes we think, oh, did we make a phone call? When the person is in our office, are we clearly conveying the information to the client? And many times we don't see the bill itself as a medium of communication. However, it is. When we are able to describe what we have done for that client in a bill, that is communication. So, and further, the more we communicate with the client, we are building a relationship with that client, and the client is more willing to pay our bill when we have that relationship, when we've established that strong relationship. In setting the fee, then, we need to first consider what it is, how complex the matter is that the client is presenting to us, and discuss with the client beforehand as to what that fee is going to be, and get a sense from that client as to whether they are willing to pay the fee. Even though as lawyers, it's important that we allow access to the legal system or provide for justice, because not everyone is able to pay for legal representation. We still have to be mindful of the fact that if we are going to do what we call pro bono work, it should be under our control. We should choose to do pro bono. Do you all understand what I mean by pro bono? And pro bono means that you choose to do it for free and you are not paid for the service. Anytime that you are going to do work for free, it should be your choice. You go into that transaction knowing that you're going to do it for free. The worst thing is to do it for free because the client has put you in that position where you have an expectation of payment, and when the client does not pay, you've in essence done it for free. That is what we call involuntary pro bono. You were put there because the client put you there rather than you choosing to go there. So in setting the fee and talking with the client before you agree to represent them, have a sense of whether that client is interested in paying you, number one, and number two, paying you the amount that you believe is fair for that engagement. It has been shown that, and this is, clients are just like any other consumer. We are providing a service, and they are a consumer of this service. And as a consumer, they treat us just like anything else that they are purchasing. As consumers, we all tend to buy what we want, but not necessarily what we need. And as lawyers, when we talk to the client about what they need, they may not want to hear it. They know what they want. They're willing to pay for what they want, but not necessarily for what they need. So when we are having this conversation about what they need, we may be willing to provide some services based upon what they want, and they're willing to pay for that. But more importantly, are they going to pay us for what we believe they need? Because at the end of the day, if we only provide them what they want rather than what they need, that is a lawsuit waiting. Because later on, when what they need is pressing upon them, and we did not handle it because we said, well, you did not pay for it, so we did not do it, then they will sue you because now they are in a lurch. They have problems because what they needed did not come, and they need, and they're hurting, and they're going to sue you. So it's best to, if they have a need, to explain to them that they have this need. And if you were going to be their lawyer, it's important that you represent them to take care of that need and that they would have to pay. If they now have an understanding of how important it is and are willing to pay, then you can you represent them. Otherwise, don't represent them unless you choose to do pro bono work. The other tip I want to give about billing and collecting fees is when someone calls on the phone. I know in the States, many potential clients are very price sensitive. They call up several lawyers asking, number one, do you handle this particular matter, and how much does it cost? I don't like giving a fee, estimate giving a fee over the phone, because all they really are going to do is it either meets their price requirements or it doesn't. If it doesn't meet their price requirements, they hang up the phone. If it does meet their price requirements, then they may come in. The problem is once you've given them a price, they are set on that price. They become anchored there, such that now when you talk to them in person and you find out that the case is more complicated than what they had indicated over the phone, they are not willing to move from the price you gave them over the phone. And you appear to be deceptive, money hungry, and the like. And that gives the reputation that we are just out for money and so forth. And that's not the case. It's the fact that they did not give us that information over the phone. Plus, the question becomes, as managers of your firm, for you to ask the question, do you want clients who are price sensitive? Meaning that once you go beyond their price, they move to another lawyer. There are some practice areas that, and I'm sure it's probably the same here, but in the States where you see that client only once. And so once you've engaged them, you will not see them again. We have, for example, in the States, personal injury law, where if someone gets hit by a car, they might sue the person who hit them. They don't plan on getting hit often. So we only will see them hopefully once. Okay. So for that person who may be price sensitive, it may not be so difficult. But if this is a client, let's say a business client, who you hope to build a relationship and have other legal issues presented to you, the question becomes, do you want a client who is price sensitive? You want to spend time with someone who you can build a relationship with, that you would have future business. It is most cost efficient to have a client who will send you work over time than trying to create new clients. It is cheaper to you have one client bringing you business over time and you developing that relationship than you spending your money and your time trying to find new clients. So if you have this one client that you say is worthwhile to build a relationship in hopes of getting more business from them, if that person is price sensitive, they will be seeking to keep that price low all the time and maybe lower than you're willing to charge. So someone who calls you on the phone and does not want to come into the office but insists that you give a price over the phone may be someone you would not want to have as a client. In the states, we also have when we get money up front, we not only get money up front based upon the fees, but also on costs. So we have the distinction between the fees and the costs. I mentioned before that we have trust accounts so that any money we receive in advance of our earning it, we have to put it in a trust account. And we keep track of the amount that is in advance towards fees and in advance towards costs. And we would have it detailed that if my fee is, let's say, 20,000 dirham, that's my fee. But I might have 2,000 dirham as costs for court costs and experts and so forth. I have to keep track in the States. I